Part 3 and 4 includes directive principles of Indian citizens, and Part 4 state policy, and both of these are the conscience of the Constitution, the main parts of the Indian Constitution. Part 3 of Indian Constitution has been described as Magna Carta of India. So usually a question is asked, what is Magna Carta of India? So that is the directive principles of Constitution is called Magna Carta of India. Article 12, definition of state. Now what is a state? In this part, unless the context otherwise requires, the state means government and parliament of India, government and legislatures of each state, and all the local and other authorities within the territory of India or under the control of government of India. Article 13, laws protecting the fundamental rights. Article 13(1) includes all the law in force in the territory of India immediately before the commencement of the Constitution, insofar as they are inconsistent with the provisions of this part and shall to the extent of such inconsistency be void. So what does it mean? Article 13 has got parts. The first part says that the law which is in force is all with relation to the Constitution of India, the rules written in Constitution of India under Article 13, so far as the consistency is provided to the extent of the rules written under Article 13. So whatever the thing has to be followed, it will depend upon the rules which are written under Article 13. Now Article 13(2) states or tells that the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made and contravention of this clause shall to the extent of the contravention be void. It means what? It means that any of the state cannot take its own decisions if it is against the rules written under Article 13(2) by the Constitution. It has to be followed by each states. Article 13(3). This includes the definition of law, what is a law, and definition of law in force and what is to be followed by the states. Article 13(4) includes nothing in this article shall apply to any amendment of the Constitution made under Article 368. So under Article 368 there are fundamental rules which has to be followed as per under Article 13(4). Exceptions to fundamental rights. Now we have fundamental rights, but there are certain exceptions in Constitution for each citizens. Fundamental rights are individual rights enforced against the arbitrary invasions by the state except in case of Article 15(2), Article 17 and Article 18(3)(4), Article 23 and Article 24. That means the fundamental right has got exceptions in the cases of these articles, where these can be enforced against private individuals also. So this is also applicable of the exceptions in case of the private individuals or anybody for that matter. Fundamental rights are not absolute rights, and the state can put reasonable restrictions on the grounds of. So fundamental rights can be flexible in terms of certain reasons by the state legislature or state government. So when a state gets a flexibility in fundamental rights, when it is in relation to advancement of scheduled caste, scheduled tribe, other backward class, women or children, general public orders, decency, morality, sovereignty, integrity of the country, security of the state, or friendly relation with the foreign states. So in these matters, the rules which are written as fundamental rights become little flexible in terms of various provisions given under Article 15(2), 17, 18 and 23, 24. The 6 fundamental rights. What are the fundamental rights? Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, rights to property, right to constitutional remedies. So all 6 fundamental rights are divided under various rules. These rules comes as Article 14 to 18, right to equality, 19 to 22 right to freedom, 23 to 24 right against exploitation, 25 to 28 is right to freedom of religion, 29 to 30 is cultural and educational rights, 31 is right to property, and 32 is right to constitutional remedies. Now right to equality, the first one, Article 14 to 18. Now 14 article says equality before law. 15 article prohibition of discrimination on grounds of what? Religion, race, caste, gender, sex, or place of the birth of person. Article 16 is equality of opportunities in matters of public employment, equality to each and every individual. Article 17 is abolition of untouchability, and Article 18 is abolition of the titles which are given to people, higher class, lower class, and so on. Article 14, equality before law. The state shall not deny to any person equality before the law or equal protection of the laws within the territory of India. So all are equal as citizen of India in terms of the rights. Article 15 is prohibition of discrimination on the grounds of religion, race, caste, sex, place of birth. So Article 15(1) says the state shall not discriminate against the citizen on grounds of any of the things like religion, race, caste, sex, place of the birth of, or any such matter. 15 Article 2 says no citizen shall on the ground of only religion, caste, race, sex, place of the birth or any of them be subject to any disability, liability, restrictions or condition with regard to going access to the shops, public restaurant, hotel, place of the public entertainment, the use of the well, tank water, bathing guards, roads, places of public resorts, maintained wholly or partly out of the state funds or dedicated to the use of general public. Article 16 speaks about equality of opportunity in matter of public jobs or employment. Article 16, 1, 2, 3, 4 and so on. So let us see Article 16(1). There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 16(2) says that no citizen shall on the grounds only of the religion, race, caste, sex or descent, place of the birth, residence or any of them be ineligible for or discriminated against in respect of any employment or office under state. Article 16(3) says nothing in this article shall prevent Parliament from making any law prescribing in regard to a class, classes of employment, appointment to an office under the government or any of the local or other authority within or state or union territory, any requirement as to the residence within the state or union territory prior to such employment or appointment. Article 16(4) says nothing in this article shall prevent the state from making any provisions for the reservation of appointments or the post in favor of the backward class of citizens which in the opinion of the state is not adequately represented in services under the state. Article 16 has got various divisions here as 4A, B, 55. So let us see this. Equality of opportunity in matter of public employment. So nothing in this article shall prevent the state from making any provisions for reservation in matter of promotion, consequential seniority to any class, or it can be classes of post in the services, etc. Article 16(4)(b) relates to the year which are served for being filled up in that year in accordance with provision of the reservations, promotions. Okay, so all this thing comes into Article 16(4)(b). And then you got Article 16(5) which deals with the affairs of any religious or denominational institution or any member of the governing body thereof shall be a person professing a particular religion belonging to a particular denomination. So here any law which provides the incumbent of an office in connection with the affairs of any religious matters are included, rules with regard to that is included in Article 16(5). Then comes Article 17, abolition of untouchability. Untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with the law. Article 18 is abolition of titles like No title not being a military or academic distinction shall be conferred by the state. No citizens of the India shall accept any title any foreign state. No person who is not a citizen of India shall, with while he holds any office of profit or trust under the state, accept without consent of President any title from the foreign states, and no person holding any office of profits or trust under the state shall, without consent of President, accept any present emolument or office of any kind from or under the foreign state. Right to freedom under Article 19 to 22. Protection of certain rights, protection in respect of conviction for offences, protection of life and personal liberty, right to education, and protection against arrest and detention in certain cases. So as per your right you can fight. If it is not as per the right, nobody can force you in these, because of these are the protections given by the Constitution under article forms to each individual. Article 19 is a protection of certain rights, like all citizens shall have the right to freedom to speech and expression, assemble peacefully without arms, to form association or union, to move freely throughout the territory of India, to reside and settle in any part of the territory of India. You have the right. Nothing in subclasses like shall affect the operations of any existing law or preventing the state from making any law insofar as such law imposes reasonable restrictions on the exercises of the right conferred by the said subclauses in the interest of the sovereignty and integrity of India. So in short, it consists of decency and morality for each individuals, and you can understand that it should not include the contempt of court, defamation or incitement to any offence. 19 article protection of certain rights. This includes like the said clauses shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing in the interest of the sovereignty and integrity of the India and public order. Reasonable restrictions on the exercise of the right conferred by the state and subclauses. Article 19(4), nothing in the subclauses, it states that it shall affect the operation of any existing law insofar as it imposes or prevent the state from making any law imposing an interest of sovereignty and integrity of the public. Article 19(5), nothing in the clause but it states that operation of any existing law insofar as it imposes and prevent the state from making law imposing reasonable restriction. So in basically we can understand that these rights or the laws are the protection as a fundamental or directive principles to protect each individual in the country India. Now this is enough for today's class. The rest of it will be continuing in the next session, in the next part 3 of the Constitution of India. So please write down notes and keep it ready, so any moment I will take it for the corrections, and please complete those who have not completed the assignment 1 for module 1. Thank you.